Good morning. Before we come to the topic, just a word about our chief guest. You were told about his contributions as a judge, his well known judgments. But let me tell you, especially the younger generation, many of whom may not have been even born then, that way back in 1981, he had authored a beautiful piece on locus standi, which was published by the Journal of the Bar Council, and it found its place of honor in the first judge's case. Justice Bhagwati, presiding over the seven-judge bench, quoted that piece in his judgment. You will find it in S.P. Gupta versus Union of India, 82 Supreme Court 149. So that is your chief guest. He spoke about law and literature, but that is his pedigree. Way back on 25th September 1958, when the great Chief Justice Chagla retired, his eminent father, Yashwant Vishnu Chandrachud, as government pleader bidding goodbye to the retiring Chief Justice, said some beautiful words. He said, "When we read your Lordship's judgments, we feel that we are at a reception to celebrate the wedding of law and literature." That equally applies to the person who said it, Chief Justice Y.V. Chandrachud. And I had occasion to tell him that any number of times. And Justice Dhananjay Chandrachud carries that pedigree with him. Judge, if I may address you as Dhananjay, we have known each other for a long time.
Yes, of course.
We begin with, I understand, judges as builders of institutions. Undoubtedly, the court is an institution, but as Justice Frankfurter said, it's not an abstraction. It's composed of people who, with the diversities of their talent, endowment, character, ability, outlook, determine the course of its working and destiny. What would you like to make your initial comments on that? And just to add to that, a judge as an institution builder, is it just confined to the court or to other institutions of democracy as well?
Well, if we have to look at the role which is attributed to judges in a democratic society governed by the rule of law and by a constitutional text, judges first and foremost have a vital role in the outcome of cases, in deciding cases. But when you speak of the institution, the actual output of a judge in terms of the written word or the written text of the judgments is just one facet of institution building. Judicial institutions have so much more than just the actual decisions of cases. That consists first and foremost of human beings. And that's, I think, the most important capital of an institution. The human beings which interact within the four corners of that institution, not just in the physical space but beyond. The second is the systems and processes which an institution sets up. Because setting up systems and processes is vital to the role of institution building. And third, while doing all this, to create a vision for the future. So it's all three facets which ultimately go into the whole making up of the building up of an institution. And the work of a court and a judge, particularly, to answer the latter part of your question, is not just confined to judicial decisions or your own work as a judge in deciding cases. It reaches out to society at large. And therefore, there are institutions and institutions within institutions. A judge, therefore, has a vital role in mentoring the bar, which is an institution in itself. A judge has a vital role in institutionalizing fundamental constitutional values, such as due process or the freedom of speech and expression. And this is irrespective of the outcome of particular cases. So the work of a judge in contemporary society goes far beyond merely the confines of the courtroom in which she or he takes and performs roles as people who will decide cases.
What would you think should be the equipment for judges as institution builders?
First and foremost, an open mind. An open mind requires confronting your own biases and to allow for viewpoints other than your own to shape the role of the institution. Because too very often we fall into the trap of believing that our perspective is the only correct perspective. And I've seen this particularly with judges of integrity. Many people tend to believe that they are the last word on the integrity of the system. It's not like that. The system survives on the integrity of a collective body of people. So having an open mind, which is open to ideas, to thoughts from different sources, is critical to performing that role. Second, I would believe training is crucial because so very often what we have imbibed from the past is inadequate for us to handle the challenges of the present. You're just not capable of handling the challenges of the present purely on the basis of what you have received as past learning. And therefore, if you have to look at the building of an institution, I think training of judges in diverse areas, because the law is evolving very rapidly, society is evolving very rapidly. The nature of the communication skills, for instance, which judges were required to have in the 1950s or the 1960s, are very different from the communication skills which we expect of judges today. The nature of communication itself has evolved with the social media. I'm not for a moment suggesting that therefore judges while in service should be on social media. That's not what I'm saying. But the whole manner of discourse in society is continuously being reshaped by societal events, including the onset of technology. So judicial training is a very important facet of institution building. Third, it's important for judges, whether through training or through an openness of mind, to be available to receive new ideas which are required to meet the challenges of the present and the future. The role of women in society. There are conversations today which you don't find were conversations in the past. Who in 1950 thought of the importance which should be ascribed to the role of women in the legal profession? That's something which you find in the last 20 years. You had, of course, exceptional women in the professions even before that. But today's conversation in terms of giving an equal voice to the marginalized, to gender equality, to people from non-binary situations, is reshaping the whole conversation about what institutions should be like. And I think it's important, therefore, for judges as institution builders to have a feel for what's happening in social reality. Our society is such a young society, and the young in our society are constantly aspiring for change within. And I think judges ought not to be left behind in this process of change and expectation which is being generated in society.
You referred to Justice Vivian Bose And to use his beautiful language, the same idea that you have now expressed, not only the thought which we like, but the thought which we hate. I suppose that's what you had in mind.
That's right.
And what has been, if I may ask you, your personal role in institution building? I mean, we all know, but to hear it from you.
The role of a judge in institution building, and I have been a judge for I was a judge for 25 years. It traverses many layers. That role is never constant. So when I became a judge, I was asked to become a judge at the age of 38, and I was appointed judge at the age of 40. So my interface with law was based on my absorption of ideas as a lawyer. And I do find that in so many which ways, that was inadequate to the task of institution building. Because my contact with, say, just the bar or a successful legal practice, I believe did not lay the groundwork for a more inclusive approach to institution building. That really changed as I came into contact with this side of judging, namely from the perspective of the bench, where you deal with litigants of different genres, you deal with the best, you deal with, quote unquote, not so much the best. You deal with different kinds of people in society. You deal with the under trials, you deal with the convicts, you deal with convicts who are guilty of very serious offenses. And then you have a different perspective as your own experiences shape you as a judge. At a certain point of time, as you progress down the ladder or up the ladder, you come into contact with different aspects of the institution of judging. Judges who are drawn from the bar, lawyers who have become judges, who have a different perspective on life. Judges who have come from the services, the district judges, have a different perspective about life. They have seen law at its very grassroots. Later on, as you become a Chief Justice, you have to start taking decisions in regard to the future of the institution, the building up of infrastructure in the institution. But over and above all this, I think leading from the front requires you to walk the talk, because people are constantly assessing you in terms of how you are discharging your role when you make expectations of others. And finally, of course, when I came to the Supreme Court, and these were the last 9 years, 8.5, 9 years of my career, as a judge of the Supreme Court, you look at the nation in its broadest possible perspective, as opposed to being, say, in a district or at the bar or a high court judge. You look at the nation in its broadest perspective. The second thing that happens is that you, as a judge of the Supreme Court, in so many ways, you are liberated. You are liberated by the constraining influence of precedent, because you constantly know that while I am bound by judgments which are precedents for me, I also have the ability to challenge or question those precedents. And if you don't do that, I believe you're not discharging the role of a judge in society to the best of your ability. Because merely to follow something which has been laid down as a matter of blind precedent is to, in that sense, not realize the full potential of leadership. But leadership also requires you to reassess constantly, where do I perceive my institution going forth in the next 10 years? Where do I perceive my institution going into the next 20 years? How do I use the authority which I have to bring into conversation those segments of our society which have been excluded from conversation? Women, to my mind, are the chief and prime example of that. How do I use my authority as a judge, not merely in terms of the decisions which I craft, but in terms of day-to-day conversations in court, my language in court, my behavior in court, the amount of time which I give to junior members of the bar to allow for a more equal society. So the work of a judge in that sense as an institution builder is extraordinarily complex. It's not just about framing the rules of court
Or writing judgments.
or writing judgments. That's one and a very important part of the role. But the actual role as an institution builder goes far beyond. In my case, technology was a very important aspect of building up the institution. I thought that the time had come where we use technology, whether it was artificial intelligence, live streaming of courts, digitization of court records, translation of judgments, or transcription of oral arguments into written text. The use of technology to completely reshape the role of our courts. And that's obviously work in progress. It's never confined to one individual.
As Chief Justice and leader of the court, how do you balance your judicial work with the rest of the work? Because the rest of the work is so very burdensome also.
It has been my experience that, and I have had Chief Justices across the board when I was a judge of the High Court and Chief Justice in the Supreme Court. Particularly in the High Courts, I found that some great judges who occupied the role of Chief Justice were not necessarily good administrators.
Yes.
And many good administrators did not give as much importance to their role as judges. Now, this is a very tricky situation, a tricky balance which you have to preserve, because as Chief Justice, people expect you first and foremost to be a judge and perform and lead the court in terms of the work which you do as a judge. Too very often you see that, Chief Justice is focusing on lok adalats and setting up legal aid camps and going to law colleges. Well, that's all important, extremely important, because legal aid is part of the process. Mediation is part of the process. Alternative dispute resolution is important, especially in today's times. But you are judged first and foremost as a judge. A Chief Justice is said to be the first amongst equals. There's a Latin phrase, but since we are now talking about simplifying the law, I'll not use the Latin phrase. But, the crucial thing about being a Chief Justice, and which I found as Chief Justice of India, was to draw this balance between my role as a judge. So in my role as a judge, of course, we took on constitution bench judgments, some of which were pending for even more than a decade, almost 20 years.
That was perhaps your greatest contribution to the judiciary.
I thought we have to take up these important cases.
Yes.
But once you came back to court and say the next 4 hours or 5 hours, work on the administrative side actually began at 4:30 in the evening, after you had your mandatory cup of tea and some light gossip with your more colleagues who were on the bench with you. And after they left, you started your work at 4:30, and the work never stopped until it was 9:30, and then continued till midnight or even beyond midnight. And then early mornings, of course, you had to again sit down and read for the day. So it was really, in that sense, hugely enriching, while at the same time that it was challenging. But I should also emphasize this, Sudesh. I hope you don't mind my calling you Sudesh.
No, absolutely. I mean, that makes it really more personal.
When I joined the legal profession, I walked into the chambers of my senior, Mr. Temta Nandyarujana, and said, "Sir." And he said, "Look, there are no sirs in this profession. You call me by my first name," which was such a huge thing, because, it showed the equality of chambers. But one last point which I wanted to make, which is that while we emphasize the role of the leader of the institution, and both the bouquets and the brickbats come to the leader, it's important to understand that institutions are not, revolving around one individual.
Yes.
Institutions are made up of a collective body of people, a collective body of judges. In the Supreme Court, the greatest strength which the Chief Justice of India has is this diverse array of talent from all over the country which comes into the Supreme Court as judges with huge experience. Some of them may not have become Chief Justices of High Courts, but yet they have a great deal of experience from their time as lawyers, as district judges, where they have been from the service, in the committees which they have worked on in the High Courts. And the great amount of talent which comes into the Supreme Court from different parts of the country, the non-judging talent. So this was an area which I laid a great deal of emphasis on bringing to the Supreme Court a diversity of talent from all over the country. So I have officers, usually district judges, but some of them were not judicial officers, from Maharashtra, from Karnataka, from Kerala, from Tamil Nadu, from the Northeast, from Assam, from Punjab and Haryana, from Himachal Pradesh, from Uttarakhand. I'm just naming a few of the states. We had talented officers from Orissa who really brought in a great deal of diversity to the work of the Supreme Court. So this diversity is very important from Delhi. And this diversity of, the people who come and work for the Supreme Court, who man the back office of the Supreme Court, so to speak, is equally critical to the role of institution building. And I, as a judge and as an administrator, learned a great deal from people who are part of our institution who are not doing the work of judging. So you have the great talent from the judges, but you have great talent which comes into the Supreme Court, of the High Courts, of officers who come on deputation as well.
It's not uncommon that when the head of the court changes, though we have systems in place, many times the systems also change a little. Is that not something avoidable, so that we have some uniform system continuing beyond people?
Yeah, I agree with you, Sudesh, on this, that I believe that when changes are brought into a system, those changes must be institutionalized.
Yes.
Too very often, the changes which are brought into a system are treated to be individual-centric. Sometimes you find that this is exploited by maybe the bar on some occasion. It can be exploited by various other quarters to sort of suddenly mark a break from the past once there's a change in the helm of the administration. Speaking for myself, I always believe that the changes which you bring about must be institutionalized.
Yes.
And therefore, setting up institutions and processes within the institution is as important as taking actual decisions. So, what benefit would we have if, say, a Chief Justice says, well, I'll digitalize all the records, and then that Chief Justice leaves and, that, pales into the background. So, it's important that we continuously ensure that we build on the platform which has been left behind us by people who occupied the institution before us. That, in that sense, will promote a sense of continuity in the institution and allow succeeding generations of leaders to build from where we have left off earlier.
And it's also not uncommon that even in the same court, different benches have different methodology. That also, I think, is something that could be avoided, like in the listing and all. I'm not talking the Supreme Court, you would be in the high courts. Each judge has his own. Both may be right, but is it not better that we always have some kind of a uniform system? Because ultimately it's the system of the court, not of Mr. Justice X or Mr. Justice Y. Some take up orders to begin with, some take up hearing to begin with.
I think, again, the point which you have made is really well taken, which is that, when you speak of a two-judge bench, a division bench in the High Court, or a full bench of the High Court, or a single judge of the High Court, yet it's not a single judge, but it's the High Court speaking through the single judge. So this is very important to bear in mind. There are certain areas where obviously individuals with personalities give their own imprint and the imprint of their own personality to their work. Maybe in how you write, maybe in how you conduct your court, and the openness to dialogue. Everybody brings their own personality to the work which they do. But I agree with you completely that on certain areas there has to be uniformity. And that uniformity is necessary because you are dealing with the bar. And the bar must expect a degree of certainty on how cases would be taken up. you're also dealing with real life cases of citizens. Now, if a particular high court has, say, 35 or 40 benches, and you have 40 different procedural modalities which are followed, there'll be chaos. And therefore, when it is said that, the Chief Justice is the master of the roster, which is a highly debated phrase in today's times, the purpose of this is to bring in a degree of uniformity, because the institutions cannot otherwise function.
Survive.
And they cannot function efficiently unless there is a certain well laid down procedure which adds to certainty, objectivity, and transparency, whether it's in the creation of the roster, whether it's in terms of the procedure which will be followed, whether it's in terms of the practice directions. Speaking for myself, I also feel that if an individual judge in an institution has a certain quibble about a particular decision, the correct thing is to go to the Chief Justice and have a conversation. Laying it up for a public dialogue perhaps detracts from the value of institutional roles. So if you have an issue, the best thing is to talk to the Chief Justice and get it sorted out.
Talking of reading files, I remember a famous quote of your late father, that judges must read to meet and not beat counsel. Would you like to say something about that?
So, if all of you didn't follow what Sudhi said, he said it was said by a former judge of the Supreme Court that a judge must read the file to meet the counsel, not beat the counsel. So the M is important and not the B. I completely agree with this line of thinking. On an average in the Supreme Court, on a Monday or Friday, you have between 60 to 80 cases which are listed. And this does not include the tagged cases. Now, the tagged cases, so you have 20.1 going up to 20.22 or whatever. Now, what is the purpose of a judge reading the file? The purpose of a judge to read the file is not to assume the role of a lawyer. Because then why do you have lawyers and why do you have judges? Any more that a lawyer's role is not to decide as a judge decides. Sometimes lawyers also make this error in presuming that they have the authority to decide what is the correct view in this case. Good heavens, no. A lawyer is appearing in that case because you're paid to appear for that particular party in a case. You're not making a moral judgment on the worth of your client's position. Likewise, I always felt as a judge that however carefully I had read my 60 files or 70 files, the lawyer had read that particular file. That lawyer had read that particular file, had a conference with the instructing advocate, with their own team of juniors, spoken to the client. And therefore, the object of a judge must not be constantly to persuade the lawyer on why that lawyer is wrong. Sometimes good judges also fall into this trap, which is to persuade lawyers into believing why they are wrong. It's no part of a judge to persuade a lawyer into understanding why they are wrong. The judge must have a dialogue with a member of the bar to give your perspective to the lawyer so that the lawyer understands what your perspective as a judge is.
And comes out with his own
And comes
response.
out with that, with the response. But therefore, the way I particularly read a file through my days as a judge of the High Court, the Chief Justice of the High Court, or as a judge of the Supreme Court, and finally as Chief Justice of India, was to understand what the essentials in that case were, and never to conclude yourself, because you must have that open mind. And so many times I can share with you my prima facie, again, let's exclude Latin, my initial view in a matter was very different from the view which I ultimately took after hearing lawyers, because that's what lawyers on both sides are there for, to test the validity of an argument on forensic combat. So while you read papers to ensure that you're in charge of a conversation, that you're not taken for a ride in court, that the duration of an argument is not interminably long. But at the same time, you have to understand that there is another stakeholder in the process, namely the bar and the litigant, especially if there's a party in person. And therefore you read to understand and not read, as you said, to beat the lawyer.
And just one final word now, talking of reading. Daftari is supposed to have said that more than reading a brief, you must spend more time thinking of it. I'm sure it applies to judges also.
Oh, of course. Absolutely. Ideally, I mean, you should be closing every case for judgment and then delivering judgment some other day, so you have more time to think. But that doesn't happen always. Just the pressure of time. So also I felt that delivering shorter judgments in the court, even if it took a little time, was valuable because you had both the lawyers before you. It added a degree of transparency.
That's what Chagla always did.
That's right. It added a degree of transparency that you asked questions from the lawyers and then you delivered judgment on the spot. The lawyers knew what to expect. There were no surprises. Now that doesn't always happen. You may have a very important constitutional case in which we have to ponder over the issue and then deliver judgment. There are cases and cases, but I know of high courts which have the tradition of oral judgments. That's why we call them oral judgments, which means that it's a judgment which has been dictated orally in the court and taken down by the stenographer.
Thank you so much. I would have loved to continue, but I understand the time is running out for the next session. And
sure.
It's been a great pleasure.
Can we just have one particular, just maybe for 2 minutes? There's one area of today's conversation on inclusiveness.
Yeah, may I ask you something?
Diversity and if we just have the permission of the permission for 2 minutes, maybe because there's so many young women lawyers here, and I think that's something which we should speak on.
Yeah. What would you like to say? Because India essentially, apart from just not the law, but India essentially is a great, perhaps the finest example of unity in diversity. And we should not have uniformity, but while everyone is in the mainstream, no one's identity should be forgotten or lost. The identity has to be maintained. Inclusiveness in the overall scheme of things, tempered by equity.
The reason why I thought I should raise this, though, I mean, our time is up, is because of my concern that the legal profession for very long, and to a certain extent even today, is feudal and it is patriarchal. It was so when Cornelia Sorabji made her first attempt to join the legal profession. Things have changed because the very presence of women in large numbers in our legal profession is changing things. But yet you find that you do not have a level playing field for people. For one reason, appointment of juniors in chambers is something which takes place, by word of mouth, the old boys circuit. How do we ensure that first-time entrants into the legal profession have an equal platform to demonstrate their ability to succeed? Chambers must be more forthcoming in terms of advertising. Maybe on the website of that particular court that I have need for 2 juniors this term, or I'll be taking up 3 juniors, of promoting a more gender diverse policy. For third, of ensuring that you actually pay juniors. There is a perception that when juniors join chambers, they've come there to learn. My own understanding when I became a judge of the Supreme Court particularly and had a large number of very talented young law clerks was that while I mentored them, I learned a great deal from my law clerks because they represent the voice of the present. They have a clear idea of what's happening on the ground in social reality. So I learned as much as I shared from the youngsters with whom I came into contact with. In the Supreme Court, for instance, appointment of law clerks. We used to appoint law clerks merely by getting applications. We changed all that. We now have a competitive examination which is held at over 20 centers across India. There is a competitive examination in 3 parts. I'll not take too much time because we have to go on to the next session. Then interviews are held. The law clerks who are going to be appointed also give their preferences of which judge they want to work with. So it's a 2-way process. Now, the purpose of doing this is to open up the legal profession. We designated as many as 13 women as senior advocates in February of 2024. And in August, we designated another 10 women. So close to 22, 23 women were designated as senior counsel. I think all courts must make this effort to actively recruit young women into the higher echelons of responsibility. We must do that if we have to give an equal platform to different groups in our society, people who belong to the marginalized segments of society. There is some great work which is being done today by initiatives like the IDEA initiative of Professor Shamnath Bashir, or the SEED initiative, which was done by my former law clerk, who is now with the National Legal Services Authority, Anurag Bhaskar. The idea of doing this is to encourage people to have an equal role to play in the legal profession. Otherwise, people who come from marginalized segments, they never get the right clerkships. They never get the right internships. They don't have the cultural capital which, say, people from the larger urban areas have in the legal profession. So it's up to all of us, I believe. And so many of these youngsters who are in the audience will be one day becoming seniors in their own rights, by virtue of age as well as by virtue of your attainments. And it's important that we as institutions do everything that we can to ensure a more diverse legal profession. We had this lawyer called by the name, I'm sure she wouldn't mind my mentioning her name, Sarah Sunny. And Sarah has, she required a sign language interpreter. Now we realized that there were no sign language interpreters in the courts. But should that mean, therefore, that a young, talented lawyer is not able to present her or his argument because there is no sign language interpreter? We made sure that we have sign language interpreters in the Supreme Court. How do we ensure that, say, people who belong to the visually challenged group, that they are able to navigate our processes? We had an accessibility audit conducted in the Supreme Court. And we implemented the recommendations of the Accessibility Audit Committee. We have to look beyond, just our own immediate day-to-day work. Do we look about those, who come in a wheelchair to the Supreme Court or the High Courts? Do we think about, how a pregnant woman will be able to navigate the spaces? Does the fact that she is a woman and she's pregnant, does that affect her ability to effectively carry out the role as a young legal professional? What are the steps which we should be taking for making the legal profession a more equal workplace for people with different lived experiences? So this conversation, I think, must really, in that sense, must begin. Do we have toilets which are, clean enough, hygienic enough for women? One of the things that we did was to have sanitary napkin dispensers in toilets in the Supreme Court, incinerators. But is this conversation going down to the districts, to the high courts? How many high courts have toilets which are in that sense friendly for women? So there is no point in saying that we need more women judges, we need more women lawyers. We need to create working spaces which are conducive to young women to have a more equal profession. I think we'll conclude that.